First event involved an individual named Kirakan Palmer. I hope I'm pronouncing his first name correctly. He's here and will testify during the proceeding. The evidence is going to show that in June of 2012, Officer Booth was on patrol, conducted a traffic stop of a vehicle being driven by Mr. Palmer, African-American man. Officer Booth wrote him a traffic citation. There was dialogue between the two of them. Mr. Palmer didn't agree with the traffic citation. Evidence is going to show Officer Booth dropped it in Mr. Palmer's lap and walked away from the vehicle. Mr. Palmer took the citation and threw it out the window. And Mr. Booth came back up to the vehicle, announced that Mr. Palmer was under arrest for littering violation of ordinance. The evidence is going to show that Officer Booth told Mr. Palmer to get out of the vehicle. He was under arrest. Mr. Palmer didn't get out of the vehicle. The evidence is also going to show Mr. Palmer did nothing forcibly whatsoever towards Officer Booth. Didn't punch him, didn't take a swing at him, didn't pose any threat of harm whatsoever to Officer Booth. You're going to hear that another officer, Officer Justin Rainham, provided backup to Officer Booth during this stop. He was on the other side of the vehicle. Remember that name because that's the name that's going to come up here in a few minutes and also throughout the hearing. And notwithstanding the fact that Mr. Palmer wasn't showing any aggression towards either of these officers, the evidence is going to show that Officer Booth started punching him in the head. Meanwhile, the other officer is holding the weapon to Mr. Palmer's head. When the punches start getting thrown, Mr. Palmer goes in defensive mode. Officer Booth pulls him out of the vehicle. The evidence is going to show that Officer Booth was hitting Mr. Palmer on the left side of his face, but Mr. Palmer had significant injuries to the right side of his face. Busted lip, blood, cracked teeth. And the reason the injuries were on the right side of his head is because when Officer Booth pulled him out of the vehicle, he decided to introduce Mr. Palmer's head face first into the vehicle, smashing the right side of his face into the vehicle. And at that moment, Mr. Palmer was handcuffed, placed under arrest for littering. Now, as the circumstances would have it, there were witnesses that were around to see this incident. Law enforcement officers from Daytona Beach responded to the scene. The sergeant for Officer Booth arrives, and these witnesses are informing the law enforcement folks that are arriving on scene that what they saw wasn't right, that the officer hit this guy. And so Sergeant Smith goes and asks Officer Booth what happened, and Officer Booth's immediate response is, well, I don't really know, I blacked out. Sergeant Smith continues to question him, and at some point Officer Booth says, well, you know, maybe I was a little bit too excessive with this one. Mr. Palmer was taken in, arrested. He files a written complaint, citizen's complaint against Officer Booth. That was submitted internally, and the Department of Professional Standards, I call IA, conducts an investigation of this incident, serious allegations against Officer Booth, and at that point in time, Mr. Palmer goes and hires an attorney to represent him not only criminally but in civil proceedings against the city and Officer Booth. And Mr. Palmer doesn't continue to cooperate with the city in its investigation, and so ultimately the city closes out its investigation without making any formal findings against Officer Booth, notwithstanding the fact that the basics of this incident are pretty well spelled out. But given the Police Officer Bill of Rights protections that Officer Booth had, they didn't find him guilty of anything, but they did send him back to retraining, basic law enforcement training at the police academy, so that this incident, this type of aggression didn't happen again. Fast forward a year later, June of 2013, and another incident occurred, which you're going to hear about and see, in fact, involving Officer Booth. On or about June 13th, 2013, early morning hours, he and another fellow officer, the one I just told you about, Justin Rainham, are close to the end of their shift. They decide to go park below one of the bridges, Seabreeze Bridge here in Daytona Beach, to talk towards the end of their shift. Nothing wrong with that. And when they arrive at that location, they see a vehicle parked there, a little red Mazda Miata, something of that sort. And there's a woman that was there with the vehicle, who you will come to learn is a woman by the name of Christine Chippewa, can't weigh any more than 100 pounds. 4 o'clock in the morning, these officers realize she's the only one there, somewhat unusual, not necessarily the best of circumstances for a woman to be there at that time of the hour. So they go up and they talk to her. And nothing wrong with that either. Ask her what's going on, get her driver's license, get her registration, everything checks out, no warrants for her arrest, has some small dialogue with her, and leave her there. Now, she reports to them that she was there because she had run out of gas. It's 4 o'clock in the morning. They don't do anything to try to assist her at all. Don't take her to get gas, don't offer to go get her gas, don't transport her, don't call anybody. They don't do anything to assist her. But they leave her there, and they go back to their vehicles and start talking. Now, part of this first encounter was captured on video camera, because at the time, the other officer, Officer Ranum, had a body camera that he wore when he was on duty. During that time period, and continuing even to today, the Daytona Beach Police Department is phasing in the use of body cameras for all of its officers to wear. And it was a phase because of the expense and so forth that goes along with it. That this was a phase-in process, and during that time period, Officer Ranum was one of the officers who had a body camera assigned to wear it while I was on duty. I think the evidence here will show that really there's not any dispute between the parties. I believe that Officer Ranum had his prior history and problems with the city and had a reputation as being a rogue officer, and had issues prior to this incident with the use of his body camera. But the initial part of this encounter with Ms. Chippewa was partially captured on Officer Ranum's camera. Two of them go back to the vehicle. They contend they talk for 10, 20 minutes, something along those lines. And then the two of them decide to re-engage Ms. Chippewa, who's still sitting there. Now, Officer Booth will, I suspect, testify during this hearing, he certainly has throughout these proceedings, that he observed Ms. Chippewa to be engaging into what he deemed to be suspicious activity. What you will learn during this hearing is that we won't see what that suspicious activity was because Officer Ranum doesn't have his camera on. So we can't see this, what the grievant contends. She was waving her arms, bouncing around, flashing lights off. We don't see any of that. Ranum's videotape isn't on, and when they reapproach Ms. Chippewa, likewise, the evidence is going to show that Officer Ranum did not turn on his video camera. So they go back, they re-engage her, they have a conversation with her. The first time they talk to her, they observe no criminal behavior from her, nothing that identifies to them that she posed any risk of harm. And likewise, when they reapproached her, same deal. They saw no criminal activity. She wasn't posing a risk of harm. Ranum asks if he can search her purse. She hands it to him. Booth asks if he can search her car. She says, sure. He goes in and searches the car. Once again, none of this is on the videotape, as you will see here during the hearing. What you will hear, however, is a recording, a radio recording of the events of the moment that these officers re-engage Ms. Chippewa. We're going to play that during this hearing. And what you're going to hear is you're going to hear Officer Ranum identify he's got Ms. Chippewa. Dispatch reports back at about 1 minute and 25 seconds on this recording that Ms. Chippewa is someone who had a prior history for introducing contraband into a detention facility. And less than 10 seconds later on that video, on that audio tape, you're going to hear Ranum yelling, spit it out, spit it out. Because what Ranum contended throughout the investigation, what Ranum contended in his police reports, is that he saw this woman put drugs in her mouth in a baggie. Now, Booth says he doesn't see any of that because he's in the vehicle. But what you will hear on the radio transmission is literally within 10 seconds of dispatch confirming that here's a woman who they suspect is involved in criminal activity, but they've observed none. Within 10 seconds of that, Raynham is yelling, spit it out, and Booth is calling for backup assistance. So what we know and what you will hear during this hearing, I believe out of the grievance mouth, is that when he sees that Raynham is on the ground with Miss Chippewa, he decides to enter this fray. He will tell you that Raynham has her completely under control. She's a small woman. You will see for yourself. She's here to testify. He has control of her. He's yelling at her to spit it out, spit it out. And according to Booth, Raynham tells him she's trying to swallow drugs. Now, what you're going to hear is that Officer Booth decides that he's going to try to fish these drugs out. Now, she's not swinging at anybody. She's not posing any risk of harm to anybody. They're not in any fear of their own personal safety at this moment. Raynham is on top of her, and here goes Officer Booth sticking a flashlight, he calls the flashlight technique, into her mouth. Now, you will hear no evidence in this hearing of anybody in the Daytona Beach Police Department being trained on what he calls the flashlight technique. You will hear Officer Booth tell you, no one ever trained him to shove a flashlight into a suspect's mouth. What he will tell you is that when he shoved the flashlight into her mouth, he couldn't get his hands in there. The flashlight's covering it up. So what he contends he does next is he tries to force her to spit out these supposed drugs by pinching her cheeks. And at this moment that this is all occurring, the grievant had never seen any drugs. He hadn't seen a baggie, hadn't seen any drugs, didn't look in there and see anything. So now he starts pinching her cheeks like this to try to force her to do something. And what he's going to tell you is that as he was pinching her cheeks, that she was biting down on her own cheek so hard that his thumb was trapped and he couldn't get it out, and that it was causing pain for his thumb. That's what his testimony, I anticipate, is going to be here today, because that's been his testimony up until now. And so what Officer Booth does at that moment is, don't know if it's a kick to the head, because that's what he initially calls it, or a knee strike to the head, or knee strike kick thing, whatever he calls it, because he changes his terminology throughout these proceedings. But he applies significant force to her head, and in his words, he gets his thumb free from her biting down on her own cheek. Now, I just told you some events that I believe the evidence is going to show you during this hearing. None of that are you going to see on the videotape, because Raynham doesn't have that videotape on. We don't see any of that on the videotape. Instead, what we see is that when the videotape does come on, while these crucial moments of this encounter are omitted from the videotape, when it does come on, we see her face being held down by her hair, face down into the cement, and that man's hand in her mouth. And he's going to tell you, despite all this pain that she caused his thumb by chomping down on her own cheek, that once he got it loose by applying the strike to her head, he still decides, I'm going to go in there and try to fish something out, notwithstanding the fact he never sees anything in her mouth. So now what you will see is you're going to see his hand in her mouth for about 30 seconds, threatening to arrest her if she doesn't quit biting him, spit it out, and after about 30 seconds, he yanks his hand out of her mouth, takes his hand, pardon me, Chief, and wipes it off on her sleeve, saliva or blood or whatever. They handcuff her and place her under arrest. You're going to see those things. Now, what you're also going to see in here is that the videotape really is a powerful piece of evidence because you're going to see and hear the spontaneous, excited utterances that occur immediately after this encounter. And what you're going to hear right at roadside, because other officers show up, they respond to the scene, you're going to hear this woman announce for everybody to hear, "Why did you kick me in the head? You didn't have to kick me in the head. If you were a real man, you wouldn't have kicked me in the head." Well, you're going to hear the grievant respond to her, hot off the press, right when this is happening, is, "I kicked you in the head because you bit me." And then they have an argument back and forth about whether she bit him or not, and the other officer, Raynham, chimes in, "Oh yeah, you bit him." And throughout this videotape, you're going to hear her say, "He didn't have to kick me. Why did he kick me?" You never hear him say, "I didn't kick you. I tapped you." Nothing like that. In fact, you're going to hear her adamantly say, in a way, that the only conclusion is she got struck with some force on her head. You're going to see some dialogue at roadside. The other officer, Raynham, is the one who arrests her. Arrests her not for battery on a law enforcement officer, and neither does the grievant, because he's contending she bit his hand. Not for resisting arrest with violence, because, frankly, that flew in the face of what she did here. She was not fighting them at all. She was getting her face rubbed into the ground. But they arrest her for resisting arrest without violence and for destruction of evidence. At no time do they ever find any drugs on her at all. They take her, Raynham takes her to the hospital, takes her there for observation. She's there for several hours. Other police officers show up on scene to observe her, and she doesn't show any signs of distress as though she swallowed any drugs at all. And she adamantly denies it. What you're also going to hear on here is she's adamantly denying ever having any drugs in her mouth. I mean, you will hear that clear as day. They take her to the hospital, and what you're also going to learn in this case is that while Officer Raynham and Officer Booth are at the hospital, and keep in mind at this point, they've got somebody that they've arrested, supposedly for destroying drugs. They don't have any drugs. She doesn't have any drugs on her. Her face is mashed up. I mean, you're going to see the evidence. She's got her top of her forehead is mashed. She's got blood coming out of her mouth. She's got blood on her clothes. They know all of these things. And they know Raynham's got a videotape. So the two of them get together and, just what are we going to do now? Well, we need to go back together to the police department. And as the grievance says to a fellow officer, we need to both watch that video, sit there and write our reports together so we can get our stories straight. And the grievant himself will tell you he knew he had to do that because he needed to save his butt at that time. That's his words. That's what he's used during this grievance process. Indeed, that's exactly what happens. The two of them go back to the police department. They sit together. They turn on the videotape. Same early morning hours during the same shift. And right there, as they're sitting there, they see that the main part of this is not captured on the videotape. You can't see it. It's not on there. And the grievant knows he's got problems now because it's not on there. And so they proceed to talk to each other to recreate the events as they best can get their story together, and they put it in writing in their police reports. Those reports are in here in the exhibits. They're reports that you will see during this hearing. Interestingly, notwithstanding the fact that at the time they wrote these reports after the incident, that they had all the information necessary to write their reports, interestingly, the evidence is going to show that the grievant 4 days later actually writes a supplemental report to this incident. And what he's going to tell you is he wrote this supplemental report because fellow officer Raynham asked him to write the report. You see, Raynham, who had prior problems in the police department, especially with the use of his video camera, now has a problem explaining the fact that his video camera didn't capture the meat of this fight. And so he goes to the grievant and asks him to write a supplemental report. And 4 days later, here's what the supplemental report says. And this is his report. As Officer Raynham and I were approaching the defendant the second time. So again, they're observing all of these suspicious activities, and they're approaching her again. Here's what he writes. I observed Officer Raynham reach down to his duty belt and manipulate his Axon camera as if he were turning it on. When Officer Raynham and I went to review the video at the end of the shift, we were unable to locate the video for the second approach to the car, despite the fact that Officer Raynham claims to have turned it on, and I had watched him push the button. And so Officer Raynham gets this cover from Officer Booth, and Officer Booth, I believe, will confess during this hearing that he can't swear that he actually saw him push the button, yet he writes that in this supplemental report that he submits 4 days later. Well, what happens after this incident is Ms. Chippewa files a citizen's complaint, and unlike Mr. Palmer, she actually cooperates with professional standards. They conduct an investigation, interview her. Raynham quits. Raynham doesn't want to go through this investigation. The evidence here is Raynham quits. He's not going to get investigated. He's long gone. Booth is being investigated, and while you hear him all over the videotape saying, yeah, I kicked you in the head because you bit me, he changes his story later on to say, well, I didn't really kick her in the head. I tapped her with a light knee strike. And then later on in the deposition, in the criminal matter, he calls it, well, yeah, I guess I did kick her in the head. And so all this evidence comes out as part of the investigation, and ultimately Officer Booth is found guilty of violating police procedures, policies. His force was excessive and uncalled for here in a situation where someone was showing no hostility at all. He decided to use aggressive force. He's going to tell you he was trying to save her life. That's his excuse here for his actions. And he's also going to tell you, I believe, that he never sat through any specific training to tell him, okay, well, here's the exact scenario where someone puts drugs in your mouth. What are you supposed to do? And we contend that the common sense of any law enforcement officer, including someone of 4 years' experience like him who had been sent back to retraining, knows that in a situation like this where there's no violence being presented to him at all, you don't shove a flashlight in someone's mouth and stick your hands in there. And oh, by the way, he had no injuries, no observable injuries after this incident. No broken skin, no blood, no broken bones. There were no injuries to him whatsoever after this incident. What you will learn is that the command staff reviewed the investigation, provided various recommendations. Ultimately, Mike Chitwood, the police chief, reviewed it all. And he concurred with the internal affairs reports that concluded that Officer Booth had violated policy in his actions and had been untruthful in how he characterized the events on this occasion. And Chief Chitwood will tell you what went into his mind in determining what the appropriate action was here. He will tell you that this incident, standalone with Ms. Chippewa, is a terminable offense. However, under the totality of the circumstances, Chief Chitwood looked at the whole package of Officer Booth to determine whether or not he could be saved, whether this was an officer that could be salvaged, and Chief Chitwood's going to tell you that the incident involving Mr. Palmer, he just couldn't discard. He couldn't discard the Palmer incident, how bad it was. In the aftermath of that, the officer gets sent to retraining, and then this incident happens that he couldn't take the liability that the city would incur by keeping him employed. Indeed, the city has had dealt with threats of suit from Ms. Chippewa's attorney and Mr. Palmer's attorney, and collectively had to pay those two folks approximately $60,000 to settle potential claims based on this officer's actions. And Chief Chitwood will tell you in his own words why he made the decision to terminate Officer Booth's employment. We're convinced that at the end of the presentation of our case, the submission of the briefs, that you will agree, and we contend we did not violate any article, certainly not Article 11, subsection 2G of the collective bargaining agreement, and we will ask that you deny the grievance in its entirety.
Well, sir, off the record, we were talking about Paul Harvey and his rest of the story. Well, I'm going to tell you the rest of the story. The story, the points, the evidence, the things that somehow Mr. Wood failed to tell you. But I think as an attorney, it's our obligation to give you not just our version of the events, but the plain, unvarnished truth of what happened. Now, let's start with Kerrigan Palmer. Mr. Wood felt the need somehow to point out that he was an African-American male. I don't dispute that. How that's relevant, I don't know. There was no suggestion there's any racial motivation, no allegation of a racial motivation. So why he brought that up, I feel was probably more for a dramatic effect than anything else. But that's not really the point of the Kerrigan Palmer episode, my thoughts on that point. Mr. Wood accurately set forth the reason for the stop, that Mr. Palmer was speeding. He accurately set forth the fact that Mr. Booth wrote him a citation and that he placed it on Mr. Palmer's lap. But what he failed to say is that throughout the course of the stop, Mr. Palmer was completely uncooperative. He refused repeated requests to hand over his license. After 4 or 5 requests or commands by Mr. Booth to hand over the license, Mr. Palmer finally relents. He's written this citation. Mr. Palmer throws it out the window. Officer Booth decides at that point he has 2 alternatives. He can do nothing, or 3 alternatives. He can do nothing. He can ask to give Mr. Palmer a notice to appear, which amounts to it's a custodial situation. Notice to appear until the notice to appear is completed is a custodial situation. It amounts to an arrest. It's on scene. The notice to appear paperwork is completed, and then the person can be released on loan recognizance by the police officer without having to go to jail, without having to get fingerprinted, etc. And 3, to arrest Mr. Palmer. And for what offense? Littering. Littering is an offense in Tahoma Beach that is subject to arrest. You will hear evidence from Mr. Booth that he had been told by his supervisors repeatedly, look, we really need to hit hard on these quality of life ordinances in Daytona. Littering, loitering, sleeping in the parks. We need to hit hard on these things so we can clean up the area. And he was simply just on to follow the order when he reapproached that vehicle to either give Mr. Palmer a notice to appear, or the other alternative then was to arrest him. Well, he goes up to Mr. Palmer's window, intending to give him a notice to appear, asking him to step out of the car so he can do the custodial portion of the notice to appear. Well, Mr. Palmer refuses to get out of the car, grabs onto the steering wheel, refuses to get out of the car, won't move, won't get out of the car. Mr. Booth, or Officer Booth, opens the door, which is unlocked, and tries to grab a hold of Mr. Palmer to get him out of the car, because this is a custodial situation. He's well within his right to remove Mr. Palmer from that car for his own safety, or concern there may be guns or other weapons in the car that could serve to harm Officer Booth. Mr. Palmer engages in a struggle with Officer Booth. Now, you heard Mr. Wood claim there was nothing forcible, that he was putting up no resistance. There was no threat to Mr. Booth. Well, throughout the period of time that Mr. Booth was out Mr. Palmer's window, the evidence would show that his engine was running. And that when Mr. Officer Booth opened the door to lead inside to grab Mr. Palmer during that struggle to get him out of the car, Mr. Palmer puts his hand on the steering column where the gear shift is and tries to put it in drive. And that's what leads Mr. Booth to punch Mr. Palmer in the face. And that's a perfect, you'll hear testimony throughout the course of today that that's an acceptable thing to do in the event in that situation, to apply a distracting move to prevent the person from trying to flee. Nothing wrong with that, and we'll hear more about that later. But Mr. Wood said no aggression. He was just a simple man on a simple joyride. Rebecca Sunnybrook Farm, not posing a threat to anybody. That's the farthest thing from the truth, sir. But the evidence will help you help you understand and grasp that position further as we go farther down the line here. Now he said that Sergeant Smith spoke to Mr. Booth, Officer Booth, on the scene. And he says that, Sergeant Smith says that Officer Booth said, I blacked out. I don't know what happened. You'll even see in Sergeant Smith's IA statement that he claims that Officer Booth made an admission that I used excessive force. Well, those are pretty explosive things, don't you think? You have an officer that admits, according to Sergeant Smith, that I blacked out. I don't know what happened. I used a little excessive force. What do? He continued to shift. They didn't take him out of service. You think a rational, sane human being charged with the protection of the public would, in that circumstance, if what they're saying is true, take him out of service. Send him to EAP. They didn't do that. He worked that night. He worked the next night. He was never taken out of service at all for this situation. He continued to do his job. He continued to do it well. And nothing was done. Nothing was done to see if he needed help, to take him out of service, to protect the public or protect Mr. Booth. So I kind of question, honestly, how in the heck Sergeant Smith can make these observations blacked out, don't know what happened, he used a little excessive force, and yet do nothing. And these things were reported on, and the city did nothing. Now the thing that really blows me away in all of this, it truly blows me away, is that they try to use the Kerrigan Palmer episode as evidence of why, in combined with the Chippewa episode, they should have terminated Mr. Booth's employment. Well, the fact is, and you'll hear evidence of this, that no disciplinary action of any kind was given to Mr. Booth. And he indicated that they shut down the IA because Mr. Palmer didn't cooperate. There's nothing in the city of Daytona Beach's policies that indicates they must shut down an IA if the complainant won't cooperate, if the complainant won't come in and give a statement. Think about it. Just think about it for a second. If a woman comes in to the city of Daytona Beach Police Department and complains, I was raped by an officer. She gives some information, she writes a complaint, and then she disappears. She's not able to be found. Are they trying to tell me, are they trying to tell you that they can't continue that IA to conclusion? That they can't act upon what they have and try to at least make conclusions? Unfounded, sustained, exonerated. At least follow the thread to the end of the line and see where it leads. Here, Mr. Palmer won't cooperate. He's already sent us a demand letter indicating that his attorney is going to file suit. They washed their hands of it. They just shut it down, but not because they had to, because they wanted to. Yet they're still trying to, despite the fact they found no sustained violations of excessive force, despite the fact that they found nothing to suggest that he did anything wrong during the course of that traffic stop, and despite the fact that they gave him zero discipline, nothing, they tried to use that unsustained, uninvestigated fully incident of Kerrigan Palmer to add weight and emphasis and support for their decision to terminate Officer Booth for the Chippewa situation. That is absurd. And I honestly, if this were a civil court, I would seek a motion to eliminate, to prevent the introduction of any of that evidence, because it's clearly irrelevant. It's not discipline. There was no sustained finding. The IA was never concluded. They could have, they didn't. They chose not to. For whatever purposes, maybe strategic purposes, litigation purposes, who knows, who cares? The fact is, they could have and didn't. Now, the Kerrigan Palmer situation to me is nothing but white noise. It's intended to smear his character, but it's an ill-fated one, because there's no conclusion to smear him with. Nothing. And you'll probably hear me go on about this during the course of the hearing, but the fact that Sergeant Smith hears I blacked out, I used excessive force. All right, well, continue with your shift. That to me is the height of insanity. It's lunacy. If they're trying to suggest that that's true, how they acted subsequent to that makes them not just negligent, but grossly negligent. It almost reaches a level of willful and wanton misconduct on their part, not to prevent Mr. Booth from continuing on the road on that day and then on subsequent evenings. Now, I didn't want to get too far afield on the Chippewa situation. I'm forced to address some of the contentions that Mr. Wood has seen fit to throw into the fray. Now, concedes, and I'm happy he did that, he concedes that what we call the first encounter. The first encounter where the officers initially went up to Miss Chippewa's vehicle, 3:30 in the morning, at a boat ramp. She has no boat attached. She has no plaque on the roof. She's not fishing. She's sitting in the car. He agrees it's highly unusual. I'll agree with that. He agrees that it's kind of an unsafe environment. I'll certainly agree with that. And so he said, I wrote it down, there was nothing wrong with the officers approaching her on that first instance. And that's it. There's been some concern, question about whether or not there was enough evidence for that first encounter. Clearly, he's stipulated that there was. So I won't dwell there. Now, this second encounter. Now, Mr. Wood made a very big deal about the fact that Randon's body camera, was not on for the entire second encounter. Quite frankly, it wasn't on for all the first encounter. But be that as it may, the second encounter, the body camera of Mr. Randon was not on for the entire event. He does his best to try to somehow make this Officer Booth's fault. There's no evidence, and you'll hear none, that Officer Booth had anything to do with Officer Randon's body camera. Officer Booth did not have a body camera. He wasn't outfitted with one. He wasn't assigned one. So why the body camera didn't work, the conspiracy theory supporting it, all relevant. They're almost seemingly trying to put Officer Random on trial with Officer Booth. Well, that's not the case. Officer Random's not the grievant here today. He resigned. He chose to move on with his life. Now, did the city attempt to contact Random for purposes of conducting an IA? I've seen no evidence of such. They seem to be happy not to be interviewing him at all. Now, Mr. Wood also went to great lengths to say again and again and again, Mr. Booth, Officer Booth, did not see drugs on the scene and did not see drugs in Ms. Chippewa's mouth. But the truth is, he doesn't have to see it. Mr. Wood admitted and essentially stipulated that Mr. Random, no, that's the wrong word, you didn't stipulate. Officer Random told Officer Booth that there were drugs in Ms. Chippewa's mouth. Now, at the time, the evidence will show that Mr. Booth was searching Ms. Chippewa's vehicle. He poked his head up, see a struggle ensuing on the ground between Mr. Random and Ms. Chippewa. He runs over to assist, and before he lays hands on anybody, he lays a finger on Ms. Chippewa. He hears Officer Random say, she's got drugs in her mouth, she's trying to swallow them, or words to that effect. Well, what Mr. Wood didn't tell you is that that act is a felony. It's a felony to tamper with evidence. It's a third-degree felony to tamper with evidence. And by attempting to swallow evidence of a crime, she was in the act of committing a felony. Now, this notion about whether Officer Booth saw the drugs, he doesn't have to see the drugs in order to take police action. There's a doctrine that Mr. Benton Wood well knows called the fellow officer rule, where if one officer sees probable cause to believe that a crime has occurred, Officer Random sees Ms. Chippewa pop cocaine or whatever drug in her mouth and attempt to destroy it by swallowing it, that's probable cause to believe she's in the act of tampering with evidence at that point, a felony. He then tells that to Officer Booth. The fellow officer rule, and I can provide cases at the end of the hearing in the briefs, the fellow officer rule states that Officer Booth is allowed, without further investigation, without corroboration, without anything else, to simply take that information and do his best to handle the situation and to conduct an arrest. In fact, case law through the Supreme Court and the Florida Supreme Court is also clear, and I'll brief this and I'll present them perhaps at the end of the hearing, that a police officer is entitled to use force, reasonable force, to prevent the destruction of evidence. This is the Supreme Court. So you needn't worry about what our positions are. The Supreme Court has said it's appropriate to use force, reasonable force, to prevent the destruction of evidence. And so hearing this information that suggests probable cause that Ms. Chippewa is in the act of conducting a felony, he attempts to prevent the destruction of evidence. And that's where Mr. Wood and I, again, disagree. He says, Mr. Booth admitted that he wasn't trying to save her life. Well, that's not true at all. Throughout his IA, and I can point you to the provisions as we go farther during the hearing, Mr. Booth said, I was concerned about her going into cardiac arrest. I was concerned about the drugs hitting her system, and she, as Mr. Wood said, was a very small person. I was concerned that it might cause cardiac arrest. In fact, you'll hear evidence that Mr. Booth was thinking in the back of his mind of a former incident involving another citizen of the town of Daytona Beach who swallowed drugs in the presence of officers. His name was Johnny Boswick, and he went into cardiac arrest and died in the presence of the officers. So this was a rapidly evolving, very tense situation Mr. Booth was faced with. He didn't have time in this context to look at a rule book, to call a sergeant, to look back at his training manuals. He had to act quickly to prevent her from swallowing the drugs, destroying evidence, and perhaps endangering her life. None of that was said by Mr. Wood, but I'm telling you that's what he was faced with. Now, Mr. Wood speaks about the use of the flashlight never being trained. But what I'm curious to know, and it's something that Mr. Wood and I discussed before, and I don't know if this is the proper venue, perhaps we should wait until after I conclude my statement, is the city willing to stipulate? Because I intend to present evidence on this point if necessary. Is the city willing to stipulate that what Mr. Booth said was true? That the city has never trained its police officers or Mr. Booth on what to do, what force to apply, if any, in the event a suspect or a detainee is in the act of attempting to swallow a narcotic. Now, if they have not provided training on that point, I'd like to hear it, and that way I can shortcut a lot of testimony and evidence. Can I get a response from Mr. Wood?
I can't answer that question. I'll hear his testimony and we'll respond to his testimony. I can't speak for him. I've never heard his testimony complete testimony on that subject matter, so I don't know.
Well, we discussed this before, Mr. Wood.
But I don't know what he's going to say here today, so I can't give you a stipulation like that because I haven't participated in his training sessions, which he's had many.
Well, certainly you've investigated this matter from stem to stern. You would have come across training by now if it existed, correct?
This man has attended over 600 hours of training, so I mean I've not attended 1 second of his training, so I can't answer that.
Do you have any witnesses or documentary evidence that will suggest that Mr. Booth did in fact receive training on what to do, what force to apply in the event a suspect is in the act of attempting to ingest a narcotic?
We will hear his testimony, and if we deem it appropriate and we have rebuttal evidence, we'll present rebuttal evidence. But at this point, we're not stipulating to that, so it's time to give your opening statement.
I understand. I was hoping to avoid the necessity of further elongating this hearing, but I understand. Well, I don't quite understand your position, but I'll accept it. Now, so Officer Booth, I'll tell you, never received an iota training on what to do in the event a person is in the act of trying to ingest drugs. Not what force to use, no training on what force not to use. He was never told what to do. And so at this point, he was what, a 4-year officer? 4-year officer, relatively a rookie. He had not come across this particular situation where a person actually had the drugs in their mouth before and were in the act of chewing. So he was kind of left to do the best he could under the circumstances. He couldn't rely on training. He couldn't rely on anything that he had been taught. So he did the best he could. Now he'll be the first to admit that the use of the flashlight, which we'll go into great detail about later, was not the smartest decision. But you'll hear evidence of the manner in which he put the flashlight in. You'll hear evidence of other evidence that I think is important regarding the use of the flashlight. The key document that I think that the arbitrator needs to keep in mind is the notice of termination letter that's dated January 8, 2014, from Chief Chipwood to Officer Booth. Now, Mr. Wood mentioned this knee strike to Ms. Chippewa's head. He mentions it in two contexts. He mentions it in the context of there being an untruthful statement, number one, and he seems to also reference it in an excessive force context, number two. The trouble is that in the Chief's termination letter to Booth, Chief Chipwood doesn't make reference to the knee strike in the excessive force context. So again, if this were a civil court, I would move and eliminate, prevent any introduction of evidence that the knee strike was excessive force when Chief Chipwood didn't claim that it was excessive force. Now let's move on to these falsehood allegations. These things are the best, absolute best. They're my favorite in this case. Mr. Wood would have the arbitrator believe that on seeing Mr. Booth, Officer Booth, I apologize, said that he kicked this woman in the head, and that's all he said. Well, you will hear that Officer Booth, in response to a taunting kind of a scream from Ms. Chippewa, "You kicked me in the head." He did not correct her and said, "Well, you bit me in the finger." But the video, we'll see it, it's plain as day. You hear Mr. Booth tell Savitsky, "I need her." You even see him demonstrate it on the video. Now somehow, and God knows how, this information never made it into the IA. And somehow it never made it into, and Sergeant Creamer, the IA supervisor's investigative findings. But he said, Sergeant Creamer said in his IA that he told everyone on scene that he kicked her in the head. Not true. Not true at all. Now, we'll also go into detail about this defense deposition that Mr. Officer Booth gave at the time after the state decided to file an information against Mr. Chippewa on the charges of tampering with evidence and resisting arrest without violence. He said in the deposition that he said, "I kicked her." Well, the deposition says something far different. And I'm trying to be as straightforward as you can, and perhaps I'm taking more time than I should, but I think you need to hear this. He is asked, after there's some discussion about her biting his finger. Answer, "Well, it caused pain. And I tried to pull away, and I did a little knee strike kick thing." Knee strike kick thing. A knee strike kick thing? What do you mean knee strike kick thing? Well, I was kneeled down by her head, so when it kind of started to hurt, I tried to get my thumb back, and my right knee kind of did a little kick thing. I mean, it was pretty light, but then he goes on. The question is, so you kicked her in the head? I mean, yeah. So Mr. Wood tries to make it look like he made this grand admission in his deposition that he kicked Ms. Chippewa in the head, whereas his deposition says nothing of the kind. He says very clearly, "My knee hit her in the head." So, judging by the opening statements, I can tell this is going to be a long day. But with that, I'll close and we can just begin calling witnesses and trying to flesh this matter out for you, sir.